Trust Basics Part 1. But before I get into that, I have to share a couple things with you real quick. I had a family member email me and say, wow, you must really be enjoying this whole crisis. I see the only thing that you're doing is your broadcast. That's, only family can recognize that small portion. So really, this might go out to all those people that are looking at your financial planners and all the people that are in our firm that are working so hard. So I have to give a real big shout out and a big thank you to every single team member of the H&H financial companies, because they have been working. I know they've been working, because I can tell you, I have not worked this hard since I think I was 20 years old. I think this has now been about 7 weeks of 7 days a week, as well as our team. And if you recognize what's been going on, and if you're not with our firm, this is really a good time to step back and say, what are our advisors really doing for us? Because here you have one of the biggest fallouts in a recession in the stock market. So that requires tax loss reharvesting, Roth conversions. You have location optimization. Then what happened was they changed all the tax laws and they undid the RMDs. Or if I said that correctly, they allowed you to undo what you did in your RMDs. So to give you some idea, the entire financial planning team went to work as soon as the market started dropping, and they were putting in 7 days a week trying to figure out, doing the Roth calculations for everybody and figuring out the tax loss harvesting and the rebalancing. And that is typical of what they might do once a year. And they've now done it going on the third time, because the first time they did it, they did all those actions for clients. Then what happened was the IRS said, hey, we're going to delay RMDs till 2021. So they had to go back and do all of the calculations all over again. Then the IRS came out and said, oh, hey, by the way, now we're going to let you undo your RMDs. So now the team had to go back and figure out, okay, well, what happens now? Should we undo the RMD, pull it back into the IRA, and then bring it back out again into a Roth conversion? So when I look at what the financial planning team is doing on top of that, we had the Secure Act and all those changes. Then what we had is we had the stimulus package. And so, I got to hand it to them. You got 15 people there that have committed 150% to the well-being and the future financial outcome of the clients. And if anybody's sitting back and watching what their advisor is doing and then watching what our planners are doing, and it's not just the planners, they have planners assistants, and then there's the tax team. And so the tax team has gone into overdrive, because with the tax loss harvesting as well as now tax season, and then the changes within that, you have the payroll, the PPP, you have the extension until July 15th. It has just been the craziest year. So again, I'm just going to put a big thank you out to all the financial planning team in our firm, the tax team in our firm, the legal team in our firm, and then even the administrative backups, because they've been helping and jumping in on every single angle. I've seen a lot of crashes. I've been through a lot of crashes, but none of them combined all of these factors at one time. And then to layer it in, they're not even in the same office. So they all had to go home. Now you got 15 people in 15 different places figuring out a new communication. And I got to tell you, compared to some of the other businesses that owners that I've talked to, our team is, wow. Congratulations. Good job, everybody, because you have been doing an amazing job. Now, with that in mind, let me get into trust basics. And again, I'm going to talk about just the understanding, because a lot of times people go get trusts, they don't even know what they have. Or a lot of times people are convinced to get a will, and because they'll say, I don't have enough money for a trust, or a trust is too expensive, or whatever it is. I'm going to kind of clear that up for you. All right, so let's go ahead and get started here. So what is the purpose of an estate plan? Well, number one, it is to be able to reduce, eliminate, or mitigate the risks and costs if you get sick and for when you die. As you notice, I didn't say if you die, it's for when you die. So you know that in this country, our great United States, there's two things you can't escape: death and taxes. And I should have put another one in there. The third thing is cost to die. It costs money to die. The problems with the not having an estate plan is that if you don't, you could be subjected to surrogate and or guardianship court, probate, con artists. Boy, that's one I've seen so much over the years. And you'll see why in a little bit when we talk about wills and making everything public. Believe it or not, family members. Over the last 3 decades of watching estates and trusts settle, I can tell you one of the biggest issues that I have seen is not con artists and it's not identity theft. It's family members fighting, arguing. And what I also find very interesting is that when clients originally come to us and we talk about their estate planning, one of the first things they always tell us is, but our kids would never fight and argue. They get along so well. They would work together so well. That happens actually about 1 out of 3 times. Because when the mom and dad are gone and that controlling force is gone to keep peace, and then you have brother-in-laws, son-in-laws, daughter-in-laws, they get in people's ears. That's how most divorces get going. Somebody says, you have been disrespected, or you deserve better, or I know a good divorce lawyer. And it happens the same way when somebody dies and one of the children feels like they're either putting in more work towards the estate settlement or they're not getting what they thought that they should. And remember, the death of a parent is one of the most emotional things that a child goes through. And it becomes heightened when that child or doesn't get what they think that they're going to get. You have the federal government. This is a big one. You have Medicaid confiscation rules and state repayment rules. You have all kinds of federal government income taxes. You have tax on IRAs. Now you have illegal gun transfers. So if you own a gun, you don't have a gun trust, there's the possibility that whoever's inheriting it is doing an illegal gun transfer. You also have non-related parties where somebody might be going after your estate because they knew you had something. It could be a stepmom, a stepdad. It could be anybody that is not by blood. So let's start off just talking about what happens when you get sick. So the state of our healthcare system right now, it's in a poor state because it has been so overridden with lawsuits. Now what's happened is many doctors, not all, but many doctors now practice defensive medicine. Defensive medicine is, I don't want to operate on that person because if he dies, his family will sue me. I don't want to take that procedure because I'm at too much risk. And that has happened because of so many frivolous lawsuits and because of aggressive lawyers. That's how they get paid. And so it's put the doctors and the hospitals, which is why they have a full legal department, on alert, which is why they created HIPAA, and HIPAA was supposed to contain or protect data. Now, this was done many years ago, and it has gotten to the point where if you remember maybe 20, 25 years ago, you'd walk into a doctor's office, you'd sign in, and if your spouse was with you, the spouse would go in with you. They might go in the waiting room, and the spouse might even ask questions of the doctor. And now they won't do any of that unless that spouse signs off on a HIPAA release. The issue is many people have this misunderstanding when they think, hey, I went into my doctor's office, I signed that my spouse has permission to my medical information. They misunderstand that as a healthcare power of attorney, where it is not. HIPAA release is only where you are allowed to share information. Then you got the other problem is people usually just add a spouse and they only submit that form to their primary physician. So it doesn't work if you're rushed to a hospital because that's not your primary physician. It only is going to work with the doctor that is assigned to that release. And the big issue is if you need ongoing care. Well, that means either in-home care or a long-term care facility. You're going to be subjected to court supervision without the proper legal documents. Let's move to the next big problem. What is probate? Hear a lot about it, hear a lot of bad things about it, and the question is really, what is it? Well, what probate is, it's when the courts, because if you are passed away or you are deemed to be incompetent, either through mental or physical incapacitation. You could be in a coma. That would be a physical incapacitation because you can't legally sign your name. If you have dementia or Alzheimer's, you might be considered mentally incapable of handling your finances. So what probate is when you pass away, you can't sign your name to anything. So how does an asset get legally transferred to somebody? It has to go through the court systems. Now, we all know how the bureaucracy works with the government, the delays, the costs, and that's what you're subjecting everything that you've built up to, is to go through probate. What intestate is when you die without a will. The state is actually going to determine who gets what by order of state rules. You might not want a person to get it and another person to get it, but if you don't have at least a will, you don't even have a fighting chance. However, the big misunderstanding with a will is, as long as I write a will, I'm going to bypass probate and I'm going to give to who I want my assets. That is where the biggest problem and misunderstanding occurs. A will is going to go through probate. Sometimes I have to really emphasize this. A will does not bypass probate. A will goes through probate. Now, in normal times, the average time for a family to get through probate is a year or two and a year and a half, and it's anywhere between 3 to 7% as a minimum. I have seen them as high as 15% when families argue, or there's hard to value assets, or there are assets in a multitude of states, or there's non-liquid assets. So there's a lot of scenarios where probate can really go up in cost. So in a typical situation, a $100,000 estate could cost as much as $5,000 to $10,000 to settle. And the biggest issue is if people have property in multiple states, the probate must be opened in every state where there's an asset. So if you moved from Iowa to Las Vegas or Michigan to Florida and you have a house in both places, you have probate in both places. That means a lawyer in both places, a judge in both places. It's very expensive and even creates more time to get it settled. So what don't I like about a will? Well, number one, it's going to create probate. That's a given. Does not bypass probate. And the probate process is very expensive, as well as being very time-consuming and long. And unfortunately, it happens right when everybody is grieving. And what I have seen is it's giving a high probability for mistakes due to emotional clouding. When people are grieving, they don't always make the best financial decisions because their mind is somewhere else. What I have seen, a normal engineer who would be the most logical person on the face of the earth. When I've seen this happen, they make very bad financial mistakes. How do I know this? They usually come to us after the mistakes have been made. And most of the time, there's no way to undo those mistakes. And the probate process is public. Now, this is going to open up the door for identity theft, con artists, and investment schemes. We've had a lot of people come to us, and I'll tell you a quick story. Not too long ago, I got a call from a client, and the client said, listen, I was on an airplane, and I sat next to this lady, and she was telling me her story, and I don't know if there's anything that you could do to help her out. And I said, I have no idea. He said she lost all of her money. And so I said, I'll give her a call. And she told me the story. She actually married in a man that was 20 years her younger. She said it was totally, an emotional thing because she had lost her husband. She was very lonely. And this man is a part of a group of con artists that does this for a living. And he very eloquently changed the deeds to joint and then changed the deeds to his name and did this with many of the accounts and bankrupted her, meaning he stole all $6 million that she had. Now, this took over 2 years to do it. She's been to every police agency, every lawyer, and because he did it legally, there's not a thing that she could do about it. Now, some investment schemes aren't quite that intelligent and they just plain steal money from people. But at the time that you become public and everybody can see, hey, there's a probate going on, and in some states, there's even boxes at the county clerk's office in the probate material, and it says, is an estate tax return due or not? Now, that will tell a con artist or a thief exactly how much money you have or don't have. So they can actually target the wealthier people. So again, this is not a great thing to have in public knowledge. Now, 100 years ago, when it took you 4 hours to jump on a wagon and get from one town to another, and you couldn't just look up on the internet everybody and county clerks across the country, that might have worked. But in today's system, I think that's a terrible, terrible process. And the biggest issue, one of the biggest issues, is probate doesn't guarantee a single thing. It's all based upon the judge's decision. And in some of the estate planning circles that I run, we always laugh and say, it just really is based upon which way the wind is blowing, what the judge ate for breakfast, what day of the week it is. I mean, it's all up for grabs, because we've even seen judges on one day do one thing, on another day they do just the opposite. Now, of course, all judges know that they are subjected to appeals, and they don't like going up through that appeals, and neither do any of the people that are in the probate process. So generally they try to follow things, but the bottom line is if you get a heir or a claimed heir that shows their face, because again, everything has to be public, then that claimed heir can cause a lot of problems, a lot of expenses. I've even seen it where heirs will just, not even heirs, but people will surface. One issue where a client came in, husband and wife owned a business. Husband died. Of course, you run a business for 30 years and you're going to make some enemies, without a doubt. And he never had a trust. She came to me and she said, well, here's the problem. One of his old vendors who he had a falling out with has claimed that he said that he was going to give him money. And he knows he didn't, but he knows that just by claiming this, he's either going to get a settlement just to go away, or we're going to have to go to court. And either way, it's going to be time consuming and expensive. So again, the probate court process is not what I would consider a very sleek, efficient, low-cost process. So it leaves the door open to claims that the descendant said something different than what was in the will. Many times people might say, well, Ethel said that she will give me this much money. This happens a lot of times when people have home care taker or home, what am I trying to say? The nurses that come into the house. I don't know if I can think of the right term right now, but it's when they come into the house to take care of you, and caretakers. And when somebody passes away and they don't have the proper documentation, I've seen a lot of claims where these caretakers come out and say, but Bill said that he was going to give me $100,000. Now you open it up. And so if they really push it, what's going to happen is you either have to settle with them, or it's going to go through this long, drawn-out process, and then it's whatever the judge determines is going to happen is going to happen. And it also creates that potential for long and expensive legal and court costs. The other problem that probate has, in my opinion, is that it locks down assets and income. So for a grieving family that might need cash or even to sell certain assets, it causes a lot of risks. And let's look at what happens in a national crisis like a virus pandemic. Courts are either shut down or they get limited access. And there's a backlog because they don't have the people within that court system to process paperwork, and they don't have their normal machine going. So typically what happens is if somebody dies, the survivors, whether it be a spouse or whether it be children, they can't get to the assets. So if there's $15,000 to $20,000 due for a funeral, or there's a mortgage payment that needs to be made, or a property tax payment needs to be made. I've seen things go into foreclosure because people had a will. They get locked down in court. Even though an attorney might file an emergency motion to get assets released, doesn't mean that the courts will accept it. Doesn't mean you can get through the courts. Doesn't mean that the judge will hear it. Doesn't mean the judge has the time to see it. When we're in a national crisis like we are today, this presents more of a problem than ever, because you might have what we're seeing in this virus crisis. Somebody might go into a hospital. They don't see their family for 3 weeks. They die. All their assets are locked up. Family, kids, they can't get food. They can't pay their mortgage payment. They can't pay the utility payments. So again, the system of probate is not a great system. And, you might have something where you have a joint account. People always say what I call the poor man's will, poor person's will. Well, I have a joint account. Try going into a bank after somebody has passed away. And the banks, most of the time, they read obituaries and they will lock the assets down. The other thing people will say is, well, why don't I just use a TOD? The banker told me I don't have to worry about a will or a trust. I'm just going to put a transfer on death. That's where you fill out an additional application and you go into the bank and it transfers to you at death. That's fine as long as you're not sick, as long as you don't pass away. It's also fine as long as the other person isn't sick, because that if the other person is sick or incompetent to handle their money, a transfer on death doesn't work. So again, a lot of times people try to take shortcuts that end up blowing up on them. Last is there's no way to restrict or protect assets from going outside your family. So here's an example. Let's say I have a husband and a wife, and they have 2 children, a boy and a girl. And in their will, they say, I want to leave 50% to my daughter, and I want to leave 50% to my son. So here's what happens. Let's say mom and dad die in a common car accident on Monday. Now, on Tuesday, the son is alive. But of course, the assets have not transferred yet because it has to go through probate. You're talking about a 12 to 18 month period of time. Let's say 3 months down the line. Now what happens is the son dies. Who is entitled to that money? Well, remember, mom and dad died on Monday. So at the time of mom and dad's death, the son was legally entitled to that money. Now, because he didn't get it at this point, doesn't matter. It was legally his. If he's married, his wife is legally entitled to that share. So even though the son might die 3 months later, because probate hasn't settled, that money does not automatically pour over to the daughter. That money will now go to the daughter-in-law. If she remarries, if she do whatever she wants with it, but it doesn't keep it within the family. So the problem that I have with a will is there's no way to control that. Now, a lot of times, I'll give you another example. Mom and dad die on Monday. They leave the assets equally to the son and to the daughter. The son 3 months later gets divorced or files for divorce. Now what happens? That inheritance becomes part of that divorce settlement. So again, another reason why I don't like a will. And what don't I like about financial durable power of attorneys? Well, when you do a financial power of attorney, you have to choose between a springing power of attorney or a durable power of attorney. And what I don't like about springing power of attorneys is that you must get 2 doctors to agree that you're unable to handle your affairs, whether it's because of mental or physical incapacitation. Doctors now take liability for signing off, as there's been a lot of litigation when a person is later found not to be disabled, or one child goes after that power of attorney, gets 2 doctors to sign off because the child is lying. We have in many states in the United States where guardians, and these are non-related people, will get 2 doctors to agree, get the courts to assign the power of attorney to them, and then they drain people's accounts. So again, I still do not like springing power of attorneys. And then in today's world, what we've experienced is it's next to impossible to get 2 doctors to agree at the same time. Now, if you add in a national pandemic like we have with a virus crisis, and these doctors are on the front line, you might not be able to get in to see a doctor. So you might not be able to legally handle your affairs, and you might start writing checks to TV evangelists or people that knock at your door, and your kids show up and they say, we got to take over. Legally, you can't. You got to have 2 doctors agree. And then what you do is once you have 2 doctors agree, then you have to go through every single account. You have to go through every financial institution. You have to get them to agree that what you have done is legal. Again, it is not the best of the solutions. Second, probably the better solution, but not the perfect solution, is a durable power of attorney. And why do I say that? I'm saying that only from my opinion, from experience, that a durable power of attorney doesn't require the doctors. As soon as you sign that durable power of attorney, you're giving that power to the person. But I'm going to tell you some of the obstacles that we have seen. One, your kids get control of that durable power of attorney, and they want to hurt you because you have an argument with them. They legally have the right because you've given them that paper to control your financial assets. So an upset child may take advantage of a parent. It could be a con artist that steals it, and they pretend they're somebody else. They pretend whoever you've named. The other issue is what happens if your durable power of attorney is across the country? So let's say you live in New York City. Your durable power of attorney is in California. You have a pandemic and you're locked down. How does your durable power of attorney actually handle things for you? It's very hard. Then you add on the additional issue is that they might be making decisions that you don't agree with because they have not followed what your intentions are. There's in a durable power of attorney, it doesn't tell them what to pay, what not to pay, what powers that they what your likes and dislikes are. It basically says, here you go, you have full access. The other issue with the durable power of attorney, because there's been so much in con artists and identity theft, and it's so hard to get financial institutions to accept the durable power of attorney. So we know this because people will come to us and they'll have a durable power of attorney, and the kids will come to us and they'll say, we want you to help us with our money. We'll get a hold of their financial institution. We'll send them the perfectly legal and executed and notarized durable power of attorney, and they won't accept it. And why? They don't want the risk. They don't want the liability. So in today's world, the durable power of attorney, again, it's what we call a lifeboat document. And what do I mean by that? Well, when you set off in the Titanic, your engineers are telling you it can never fail. It can never sink. I don't know. I'm one person. I'd want to put a whole bunch of lifeboats on that boat just in case it does. And the trust is really the number one place where we're going to talk about. The durable power of attorney is really only if you mess up and don't add your assets to the trust. So what do you think the most common estate plan in the United States is? If you said it's drafting a will with a springing or durable power of attorney, you're right. That is what we see 9 out of 10 times. People will come in with a will and a durable power of attorney. What is a trust? Because this is our alternative. Well, a trust is just visualize it like a giant vault. And in order to get in that vault, you have to have a combination. Now, while you're alive and you're healthy, you're the only one with that combination. If you get sick or if you pass away, you've already named people in the trust that will get the combination. That's the easiest way to understand it. And in that vault, you have to put things in that vault. You have to put your house, your bank accounts, your brokerage accounts, etc. Okay? So what is it that I like about a trust? And again, I've been doing this over now 35 years, and the question is really not based on a legal aspect, but when we settle an estate and we have to deal with the financial institutions, we have to get quick access to money. We have to bypass a legal department at a long-term care facility that wants to review a durable power of attorney versus a trust which immediately passes that combination lock onto somebody else. Well, it's because, number one, it avoids probate. There's no restrictions on while you're alive or when you're healthy, what you can put into it or take out of it. And there's no restrictions on what you spend or where you spend it. Now, if you get sick, there's no power of attorney needed. The trust replaces the durable power of attorney or the springing power of attorney. Those two documents only cover assets that are not in the trust. So when there's no durable power of attorney, the trustee you've named as your backup, remember that's the person that gets that combination, they're now the ones that can handle assets, bills, and there's no lockup in the asset time. Like in a will, you die, the next day, the assets are locked down. Legally, nobody can sign for those assets. The way it works in a trust, if you die on Monday, by Tuesday, the new trustee is taken over, and there's no legal court or document or lawyer needed. Now, you can have multiple backup trustees just to ensure the continuation of management. Remember, like the Titanic, have a backup to a backup to a backup. If there is an estate tax, which we fully anticipate coming very, very soon in a big and bad way, so if there is an estate tax, a trust can potentially double the exemption that you get to save your family estate tax. After your passing, the trust can provide ongoing asset protection. Now, in trust, the video tutorial for Trust 2, or the broadcast for Trust 2, I'm going to explain the difference between a probate-only trust and a bloodline trust. But if the trust is drafted properly, it can provide multi-generational asset protection. So it can go to spouses, children, grandchildren, even great-grandchildren. And it's also depending upon the state in which you draft the trust, they could get asset protection. Some trusts or some states will allow asset protection on secondary generation trusts. So even if a child gets sued, divorced, in trouble with the IRS, becomes disabled, certain states, depending upon the type of trust you have drafted, can protect those assets forever. If a trust is better than a will, why do most people get wills? Well, trusts have been thought of only for the ultra wealthy. People will come to us and say, I don't need an estate plan. That's for some giant mansion somewhere in the British or in the English countryside for some duke. I'll explain it's not, because if you have a $100,000 estate, it's going to cost 3 to 7%. So I think the big attraction to a will is the cost. The cost for a will is between $300 to $900. The cost for a trust is between $2,500 and $5,000. And here I'm going to tell you a little story. So when I started getting into the estate planning field, I was taken under the wing of a very prominent estate planning lawyer. And he taught me a lot of the language. He taught me a lot of the drafting techniques, etc. And I'll never forget that one famous day when he said, now that you're ready for the next step, let me show you how you actually make money in this business. Now, that was never one of my main concerns, but he walked me into his office and there was a massive, massive vault, a safe. And I was a little inquisitive, and he looked at me and he said, you get it? And I said, no, I don't get it. He opened up the safe, and there must have been a couple thousand wills that he had drafted over the years in that safe. And being a young guy, I still didn't understand it. And he said, look, he said, when I draft a will, he said, I know that about 50% of these people are going to come back to me for probate. And then after I do the probate, I'll be able to draft another will for all those kids. So what if the lawyer that's drafting the will, what if they handle the probate too? Well, many law firms, and this is what he told me, he said, look, he said, no matter whether I get to probate it or not, he said, when I sell my law firm, they assess a future value to the number of wills that they hold because it's future income. So if we had an initial will cost of $1,000, on $1 million estate, and let's say that cost was $900, but if the same lawyer got to probate that $1 million estate, that could be between $30,000 and $1 million. Now that I'm going to say that differs than if you write a trust, and let's say they charge you $2,500 at the beginning and they draft it correctly, and if they fund that trust correctly, which I'm going to get to in a minute, the lawyer may never be needed again. So why wills are the most popular thing in the United States, I can't statistically tell you why, but my thoughts are people's disbelief in the need for a trust versus a will. Obviously, the cost, I think, is a big deterrent for a lot of people. But it's like that old muffler commercial, pay me now, pay me later. And I believe that, in my opinion, that the trust is well worth the additional upfront fee versus the potential for probate and all the problems that come with probate. So the question is, how do you get those assets into the vault, right? Because you've got this vault, and that process is called funding or trust funding. And how do you do it? Well, what most firms do, whether it is a law firm that's drafting it, whether it is a licensed document preparation firm, whether it is whoever's drafting the trust for you, they have two choices. They're going to charge you for the documents, and they're going to send you out the door with a 3-ring binder, and buried somewhere in that 3-ring binder is a whole list of instructions of what you need to do. Now, what my experience has been is over the years, about 9 out of 10 times when people come into our office and they're bringing all of their financial data with them, that is their tax returns, their investment statements, their insurance policies, their trust and wills, and when we review their trusts that might have been drafted 3 years, 5 years, 10 years ago, the instructions on how to trust fund are in there. However, They haven't done it. And so I've interviewed them. I said, why did you do this? Or what was the experience? And they said, well, here's how it worked. My spouse and I, our neighbor died, and he was kind of a young guy. So we got this, feeling, hey, it's time to create an estate plan. We need to get this done. So we went to the yellow pages, we Googled, we asked friends who we should get to do this. And, we kind of sorted it down. We met a couple, people that did it, and we finally found somebody that we really liked. And that's the biggest mistake. People go, well, I really like that person. That has nothing to do with their capacity or competency on drafting or protecting your assets. So they say, I found somebody I really liked and the price was reasonable. So, okay, what happened next? Well, we got the trust drafted, and then I said, well, how did that work? Well, that person called us into the office, and they asked us, who would you want to handle affairs if we got sick or die? We told them. They told us to come back in 2 weeks. 2 weeks, we come back. And on their conference room table, I hear this so often, all these papers are laid out, and they said, we want you to review this and make sure it's right. And so I'll say, well, then what happened next? Well, then my spouse and I looked at each other after about 15 minutes of reading all this legal stuff like, here to, within, there to, pecuniary amounts, estate planning, portability. And we looked at each other and says, I don't know. I kind of like this guy. He seems like he's pretty smart. He's got a nice office. He's got to know what he's doing. Why don't we just sign this thing and go to lunch and get this thing over with? I hear this so often. And then what happens is they come in years later, 3 years, 5 years later, we're reviewing things, and we'll see the house isn't properly deeded. The brokerage account statements are not properly in the account. The beneficiaries on IRAs, life insurance, and annuities are not retitled. All these things are not done. So they've paid for this trust, yet when they die, it's as if they don't even have a trust or a will because it's nowhere. It's still in that person's name. And that is a problem. So part of, I would say, 50% of protecting your assets is getting the trust drafted, but the other 50% is getting it funded and funded correctly. So the houses, the deed is changed to the name of the trust. Bank accounts are changed to the name of the trust. I know I'm harping on this, but it's really sad to see somebody, a family, kids will come in and they'll say, can you settle our estate for us? Yes, we can do that. And we'll say, do you have a trust? Yes, here's the trust. And then we say, do you have a list of assets? They bring in the assets. All the assets are outside the trust. Guess what? We got to go through probate. So that's what's so frustrating. Brokerage accounts need to be put in the name of the trust. IRAs and retirement plans, the beneficiary is changed either to the name of the trust or a special IRA trust. LLC and business interests, the shares or membership interests are changed to the name of the trust. Collectibles, could be a gun, golf clubs, jewelry, whatever it is. There's an inventory sheet with photographs. Those are added to a Schedule A of the trust. A Schedule A is simply a separate sheet to list out tangible property. Now, automobiles are, 50-50. They can be changed to the trust, but it's not always advisable because some states allow what's called simplified probate on automobiles. Not quite the same as full probate. Life insurance policies must have the beneficiaries changed to the name of the trust. And annuities do not have the annuity owned by the trust. Only change the beneficiary to the trust. Now, what do you do after you fund your trust? So let's say you've gotten your trust drafted, you've gone through the whole trust funding, everything is done now. What do you do now? Well, number one, ensure that no assets or income sources are ever in your name or a joint name. Keep on the lookout for this. I'm going to tell you another quick story. This is back, I would probably say, in the early 90s. I had a practice in Sarasota, Florida, and we had a nice estate planning lawyer that we were working with, and he came in and drafted the trust, and we worked with a client on funding the trust. We thought we did a great job. We checked, double-checked, made sure that every single asset item was in the name of the trust. Well, 6 months later, the client comes back and says, unfortunately, I've got pancreatic cancer. I've got a short time. And poor client passed away within 6 months. And so I attended the funeral, and I talked to his wife, and she said, what do I have to do? And I said, absolutely nothing. We did everything. You don't have to lift a finger. You don't have to do a single thing. You don't have to hire a lawyer. You don't have to go to court. You don't have to do anything. Everything is done. Felt pretty good about that job. And later on, I think it was about maybe a year and a half later. So apparently, there's a grieving period that everybody goes through, and this took a little while for her. And she called me up and said, hey, I finally got a chance to start cleaning out. His name was Henry. Henry's bureau, the sock drawer in the closet, and took her a year. And she went on to say that when I was clearing out his sock drawer, I was moving the socks and I noticed this little seam in the bottom of the desk drawer, or the drawer. So I moved the socks over, and sure enough, there was a stock certificate. It was laid upside down, and the coloring was the same as the wood. So I didn't even know that Henry had put it there. He probably forgot he had put it there. I said, okay, well, bring that stock certificate by. Let's take a look at it. Well, she brings it by, and, it was in a software company, but unfortunately, it was in and issued in Henry's name. He forgot about it, never brought it in. We never got it into the trust. And so at that time in the court systems in that location in Florida, it was about $2,500 to go through probate. That was the minimum cost to get it through, minimum. And this would assume that the assets were very small. Now, this asset at that time did not qualify under the simplified probate at that time. And the asset was about $750, the stock. So I said to my assistant at the time, how are we going to break this to Doris? I said, this stock is less than the cost of probate. And she had actually a pretty good idea. She said, why don't I run down to Walgreens and I'm going to grab one of those picture frames. And I said, well, what are you going to do with that? She goes, well, bottom line is she can't get this thing through probate. It's going to cost her more to get it through probate. We might as well give her a picture to hang on the wall. And so when she came back in, the client came back in, and I said, Doris, Shirley had a great idea. She said, here's what we have to do with this stock certificate. She goes, I don't understand. I said, bottom line is, it's in Henry's name. It's going to be more expensive to get it out of his name than it is going to be to get it through probate. And so time went on, and she ended up passing away, and her daughter, Lisa, came in, and we helped settle everything from that estate standpoint. And she said, I don't understand. What is this stock certificate that's sitting inside of this little picture frame? So I explained to her the story, and she said, well, what do I do with it? I said, there's nothing you can do with it. It's just lost money. So when people come in and they'll say, well, it's only a joint account for $1,500. Well, unfortunately, it's going to have to either go through simplified probate, and that may or may not be more than the account is actually worth. So keep on the lookout for any assets that are not named in the trust. Make sure that you understand you're now working under an alter ego. This is not your money. It's your trust's money. And so while you are the trustee and you control the spending, you do anything you want to do with it just like it was your own, what a trust is really doing is you are essentially effectuating your probate while you're alive. And so you are putting it into a different name, a name that is transferable. It's not in a human name. So you would sign your name as TTEE. That's acceptable. And so it's indicating that you're signing as the trustee, not as your own name. Here's another recommendation. Do not give out the paper document to anyone. We've had many cases over the years where clients would come in and their children or their spouses of children would do what's called a slip sheet. This is where, with modern word processing and computers, they can take a sheet in a trust and they can duplicate it but change who the beneficiaries are and swap it out. And unfortunately, depending upon the situation, they can claim that they are the beneficiaries. And the more paper documents that are given out, the harder it is to track it down. So I'm going to cover in part 2 of this broadcast, of this series, how to create a secure online electronic location for all your legal documents, not only to protect against the slip sheeting, but also to protect against if you are rushed to a hospital and your kids are in a different state and your kids need to give access to electronic documents to a hospital or a doctor under an emergency situation, which is not possible with paper, as we have learned so harshly, so many people have learned with the virus crisis. Okay, so don't give out paper documents, keep them in one location. Here's another thing to do with your trust. Don't ever mark it up, annotate it, or scratch out anything in your trust. Only use a valid, formatted, and notarized amendment. And here's why I say that. There's been many cases over the years where I've been hired to either act as the backup trustee or act in the estate closure process. So if I don't do that anymore, we'll advise you how to find a trustee. But if your trustee gets a trust and things are scratched out and they're annotated, they may not be willing to take action on that trust without a formal court document, a judge signing off on it. So what did you just do? By you not following the right procedure and crossing a name out and replacing it with another name or a percentage or whatever it is, you've just invalidated. And I don't say that from a legal standpoint. I say that from a standpoint of whoever settles the estate may not be willing to take the risk that they will take, that if they follow an action that you wrote and then it's later to be found out invalid, then they could be held liable. So now they got to go back through the system. It's kind of like probate. So don't write on your trust. Don't change it without the proper legal method as to getting it changed. Next, keep your trust updated based upon your health, your family, and even tax laws. So many times people will come to us and they've got a 10-year-old trust or a 15-year-old trust. Remember the estate tax laws, capital gains tax laws, these have changed probably every 2 to 3 years. People come to me and they still have an old ABC election on their trust. They don't have portability outlines. They don't have the IRA conduit language. There's so many things that change over the years. The goal is to find an amendment or updating service for the lowest cost, automated solution so that you can stay up to date. Because most of these things we find, I'll say, well, when did you get this trust drafted? 10 years ago. Okay. How often has the attorney contacted you to make all the updates that are needed? Never. So had you passed away, there could have been excess taxes. There could have been all kinds of things that could have been saved because life goes on, life progresses. Our country changes. Our country adds new laws. They subtract them. The goal of your trust is to keep this living document so that at the time that you need it, it's ready. It's kind of like making sure the battery in your car is charged, that the air pressure in your tires are right. You don't throw the tire on there and then 10 years later go, I wonder if I should check that. And same thing with the oil in your car. Your trust is the most important document because it's like the goose and the golden eggs. You want to protect the goose. Your assets are the goose. That's what's producing the golden eggs. The trust is kind of like that wire fence to keep the wolves and the coyotes and the fox and the bobcats and all those predators out to protect the goose. But, that fence, that can wear out. It could get holes in it. You just got to make sure that it is always secure. So in Trust Part 2, we're going to cover how do you choose your trustees correctly? Do you want a probate-only trust or a bloodline trust? And what are the differences between the two? And what kind of protections do you want for the beneficiaries? Do you want alcohol and drug? Do you want to protect them against spouses? Do you want to protect them against lawsuits? What do you want? Do you want to have incentive clauses, which are going to be the favorite thing that I talk about in Trust Part 2, because these are things that I've come up with over the years after managing trusts and having to give money out to kids at 18 and young kids that never deserved it because the parents or the grandparents never thought through really what could that money do in destruction to a young person. So incentive clauses and what kind of protections do you want to put in place there? And then how do you go about correctly managing and updating your trust? Also, we're going to cover how do the other estate planning documents tie into your trust? And what is the difference between the simple will and a pour-over will? What are advanced directives? We're going to cover the DPA, the durable power of attorney, the spring power of attorney, how that falls into what you're doing with your trust, and then healthcare power of attorney. So again, I think the most important thing that you can think about with your trust is look at it like this is my wall. This is my fence around all of my assets. And while you might have put that fence up once, it does need occasional checking. So with that in mind, hopefully you've learned a lot from Trust Part 1. and I'll look forward to joining you back when I cover